Thank you for joining us today to talk about data practices and open meetings during the state of emergency. If you would like a copy of the PowerPoint and the guidance from the Data Practices Office that we issued previously, I am sharing those documents now. Select the file and download to your device. I will also put this up at the end while we're taking questions as well. If you have any questions during the webinar, please send them to all panelists in the Q&A panel. You can type them in at any time. Like many of you, the Data Practices Office has been dispersed to different locations, and so we want to make sure that we can all see your questions and answer them. Thank you to those of you who sent questions in early. We've incorporated some of them here in case other people have the same questions, and also to give folks time to come up with their own. We are recording this webinar and it will be available afterwards. We'll get that out onto our YouTube channel as soon as we can. As always, the Data Practices Office is here to talk to government and members of the public about data practices in the open meeting law. We know that the important work of government goes on, and we want to thank you for your commitment to your communities and the state, especially during this time. And we hope that everyone is doing well and staying safe and staying home. We did issue some guidance over the last couple weeks on both the open meeting law and data practices, which we sent out to our listserv, and we have posted it on our homepage of our website, which you can see here. I'm going to go over that guidance briefly now and save most of the time for your questions. For the open meeting law, we wanted to highlight a few provisions that rarely get mentioned or invoked. The first one is Section 13D.021. This section allows any public body, state level or local, to hold a meeting via telephone or other electronic means during a health pandemic or Chapter 12 emergency when the conditions of that section are met. Right now, we have a Chapter 12 state of emergency, so that is also a health pandemic, so that piece of the requirement is covered. The term other electronic means is not defined, so that could certainly be some sort of audiovisual platform or something similar to the applications and platforms that a public body might use for a 13D.02 interactive television meeting. Briefly, the difference between 13D.02 and 13D.021 are if you have a meeting via interactive television under the provisions of 13D.02, all of the locations have to be open to the public and one member has to be in the meeting room. So 13D.021 would eliminate those requirements when it is unfeasible. So the first requirement is that there has to be a determination by the appropriate person that an in-person meeting is not practical or prudent because of the state of emergency or health pandemic. So that's going to be your presiding officer, chief legal counsel, or chief administrative officer. Given the current stay-at-home order that the governor issued yesterday, this is a pretty easy determination to make. However, public bodies should memorialize or document that in some way. What that looks like is going to vary based on your public body and your internal process or procedure. It might be a resolution or a formal motion. It could be a motion and then reflected in your meeting minutes. It could be a letter from your legal counsel. So that is going to vary, but I think you want to make sure that you've documented that determination. The other requirements are that all members can hear one another. The next two requirements are that members of the public body in the regular room need to be able to hear, and a member of the public body must be in the room. But for both of these, they are not required if it is not feasible. Again, given the governor's stay-at-home order, this is likely not feasible in the next couple weeks for sure. and possibly not in the foreseeable future, as social distancing guidelines will continue to likely apply. And then also all votes need to be taken by roll call. Public bodies must also allow for remote public monitoring if practical. And public bodies can charge the public if they have any costs around that. There are a number of free options out there for web meetings and teleconferencing. So in the spirit of transparency and accountability, I encourage public bodies to think about using something that is going to allow the public to hear the discussion and decision making and participate where appropriate, that is not too cost prohibitive. Obviously, the technological abilities of public body members is going to vary widely as the size and complexity of those public bodies vary. During these kind of uncertain times, people want information, and so facilitating that is really important. And this is a great way for them to get information directly from government rather than from other sources. The usual notice requirements apply. So for instance, if this is a special meeting, then notice is required 3 days prior. We have had the question about posting special meeting notice on the door of the regular meeting room. Of course, we don't know what a court would say, but given the governor's order, I think it's probably reasonable to use other avenues to provide notice of special meeting at this time. Certainly making use of your website, social media, and email are some good ways to alert the public that you may be having a special meeting. I did want to make a note about Section 13D.015, which is telephone meetings for state-level public bodies. That section requires 10 days notice. However, Section 13D.021 applies to state public bodies as well. So that 10 days notice does not apply when you're having a meeting via telephone or other electronic means under Section 13D.021. That 10-day notice requirement never comes into play for local public bodies if you're a city council, a county board, a school district. 13D.015 only applies to state-level public bodies. But as I said, if you're holding a meeting under 13D.021, then that 10 days doesn't come into play either for state-level folks. Also during this time, the provision on emergency meetings may come into play. Remember, an emergency meeting is a kind of special meeting where a public body doesn't have time to provide the 3 days notice. The only notice required is to make a good faith effort to contact media who have asked to be notified. A good practice will be to try to provide as much notice as possible to the public anyway, again, for that transparency piece, but again, that's not required. Public bodies can hold emergency meetings in conjunction with 13D.021, so it can be an emergency meeting by telephone or other electronic means. It's just that the conditions of that section need to be met. Another provision that might come into play is Section 13D.05, Subdivision 5, which allows a public body to close a meeting to discuss emergency response procedures. This is a permissive closing. It is not required. But if there are some security concerns around those discussions, this provision would allow for closed meeting. Under this provision, public bodies need to follow all the usual requirements to close a meeting. And that section also requires the public body to identify the procedure that it will be discussing. This closed meeting also needs to be recorded, and the recording must be maintained for 4 years or longer if required by your retention schedule. So if you're going to have a closed meeting to discuss these procedures, there are some additional requirements around that. Moving to some of the questions that we received about the open meeting law during this time, can our board or public body mandate that members participate in the meeting by phone or remotely? At least for the next 2 weeks, the governor has given us the answer to this question. This is one that's really outside of the open meeting law, so it's not something that we would normally be able to answer definitively. I assume that each public body can make its own rules about what requirements it can impose upon its members. So again, I think it's more of an internal process question ultimately. For the second one, who makes the determination that the use of the regular meeting location is not feasible? Section 13D.021 does say that that initial determination about what's practical or prudent should be made by one of three specific people. It doesn't say anything about the not feasible determination, but I think it's fair to say that certainly one of those three people could do it. The members of the board could do it. So those are some of the people who could make that decision. For question 3, assuming closure of a building meets the unfeasibility requirements, what are other examples that might make use of a regular meeting location unfeasible for the public or members of the public? Closure of the building certainly would count. Some buildings are locked now, as does the governor's stay-at-home order, obviously. The Department of Health and the CDC guidelines around social distancing could also be a reasonable basis for the not feasible determination if the public body can't accommodate that social distancing. Number 4, assuming it is feasible to hold a meeting in its regular location, can a public body turn away members of the public when the room cannot hold more people without violating social distancing recommendations? This situation is really going to be after the stay-at-home order expires, but in a situation where we might still need to adhere to those social distancing requirements. As a practical matter, I think that a public body should either have a space that can accommodate social distancing, and for smaller public bodies with low attendance, that may actually be possible, or just not have in-person meetings. Rely on 13D.021 to have those telephone meetings instead. I think allowing only some people in and turning others away really goes against that idea of a public meeting being open. Five, how is a meeting conducted by electronic means different from a meeting conducted by interactive television? Functionally, technologically, they might not be different at all. As I mentioned, other electronic means might be Skype or Google or Zoom, but the requirements of 13D.021 are going to allow public bodies to be flexible to determine what the in-person requirements will be when those 13D.02 requirements are not feasible to have the room open and to have somebody in the room. Number 6, do we still have to have a copy of the members' materials in the room? This is one where the law doesn't explicitly say this, but I think it's pretty reasonable to infer that if it's not feasible for anybody to be in the room, number 1, you don't have a need to have the materials there, but also it's probably not feasible for you to get the materials there. Again, in this situation, I would encourage public bodies to do the best they can to disseminate the members' materials to the public. For number 7, are actions that are typically taken by unanimous consent subject to the roll call requirements of 13D.021. The law just says that the votes need to be taken by roll call. So even if they are unanimous, like a consent agenda or approving last month's meeting minutes, they would still need to be done by roll call. This week, the League of Minnesota Cities also offered free webinars about municipalities dealing with the COVID-19 response. They offered some great practical guidance, including guidance on the technology related to holding remote meetings. I think this is a really helpful resource even if you are not a city. The webinars were recorded and you can access them at the link listed here. The one on open meetings was held this Monday, March 23rd. The series of meetings is called #WeGotThis. We like the optimism and the enthusiasm that the League has, but this is a great resource, and they also list some of those free resources to hold remote meetings, so I encourage you to check that out. I'm going to turn to data practices now. Keep your questions coming in on either topic. So while our circumstances are changing around us, the law has not changed with respect to data practices. There aren't any emergency provisions or measures in Chapter 13. So the obligations that the Data Practices Act imposes still apply. That said, there is some built-in flexibility with regard to public requests. What constitutes a reasonable, appropriate, and prompt response has always depended on the circumstances and the same is still true now. I think it's fair to say that for some, if not all government entities, it's going to take a little longer to push data out. Requests for paper copies or inspection um, are likewise going to be extended due to the stay-at-home order, buildings being closed, staffing, and social distancing guidelines. As always, we encourage you to stay in touch with your data requesters to let them know what is happening and what they can expect. As far as the data subject requests, again, the law hasn't changed, so it is 10 business days. With this one, there isn't an easy answer. Do the best you can. Stay in touch with your data requesters and let them know what is happening and what you can do for them given your particular circumstances. All right, I'm just going to talk through some considerations. You may have talked through some of these already at your entities. There'll be a lot of questions. I don't want to overwhelm people, but just some things to think about while you're trying to do your data practices from different places now. So number one, plan for contingencies. Have a plan B. Your plan A is your data access policy and your current internal procedures. Review your access policies and see what still works and what things might need to be tweaked to account for remote working. Do you need to train other staff members on responding to data requests, reviewing data in order to respond to requests? We had a question about our data practices guidance and whether we were suggesting hiring additional people to do data practices work, and I want to be clear that was not the intention of that guidance. It was really about assessing whether your entity has enough staff familiar with data practices that should the people who currently have those responsibilities be unavailable to perform those functions, can somebody else step in? At the state level, I know there's some discussion about redeploying state employees from one agency to another. So have a plan for if that happens. Think about who you want to bring in if you need more folks to do that. Encourage and facilitate email data requests where appropriate. Who will have access to the email account where the requests are being routed? It's probably a good idea to have more than one person have access to that account. Consider the ways you want to verify identities of data subjects who are asking for private data remotely and how that might be different from how you would normally do it when we're all in our offices. Remember your security obligations. Not public data, specifically not public data on individuals, must be kept secure. Consider what kinds of telecommuting policies your entity needs to have to make sure that employees working at home are keeping data secure. Do you have policies about putting government data on personal devices? Do you need to offer some training around having government laptops and government data in shared spaces with other people who might be working from home with entity employees? Also, simply, do entity employees have the software and hardware they need to respond to requests appropriately? In lieu of free inspection, you can consider whether your entity wants to waive copy fees for some data requests during this time. It's not required. It just might be easier to do that right now, something for entities to think about. Do you have the capability to offer virtual inspection? I don't know exactly what this would look like, but I think it's something that we've heard proposed. And now would be the time to think about how that might work and whether it could be something that might be able to work and that you might be able to use in the future as well. So thinking about these things and considering how to handle requests now, I think is a good opportunity to try some of these things, see how they work, and how they might improve your entity's data practices work going forward. We only received a couple of early data practices questions, so we'll go through those now before we get to your questions. If an entity's storage vendor closes because of the state of emergency, is the entity still responsible for providing access to and or copies of those records? I think it's reasonable to communicate to your data requester that the vendor is closed and that you'll provide the data as soon as reasonably possible after the vendor reopens. I think this is one of those circumstances that is really beyond the control of the entity, and practically speaking, there's just not a way to get to that data right now. If an entity closes its building to staff, must it make accommodations to permit certain staff to enter the building to make copies for data requests? Or can the entity inform requesters that paper copies will be available when the building reopens and staff are permitted to return? I think think we have to think about some of these circumstances from a perspective of what is reasonable. Given the current stay-at-home order, a data requester might just have to wait for those paper records. That being said, we expect that we're going to be responding to COVID-19 for the foreseeable future. And so it'll be incumbent upon those of us in government to adjust to our shifting circumstances and still provide that high level of service that our communities count on. So in these next couple of weeks, probably reasonable not to be responding to those requests for copies of data that are maintained in paper. But eventually, some employees may have more range of movement and would likely be able to start fulfilling those types of requests. So that's something that's going to be evolving, but something you want to stay ahead of in terms of knowing which employees would be able to move around based on priority status or whether they're essential. If you have someone going in to check on the mail, again, not during this 2-week period, but in the future, maybe that's something that they could do as well. So I know that data practices work can be challenging for entities under normal circumstances, and now it may seem like just one more hurdle. But I think now more than ever that transparency and accountability are vital to maintaining the public trust when we're in uncertain times. And fulfilling our responsibilities under the Data Practices Act is a big part of how the public finds out about the work that their government is doing on their behalf. If they haven't already, people are going to start requesting data about the government's response to the COVID-19 pandemic, what government employees were doing during this time, how decisions were made, what resources were used. So thinking about how to facilitate requests now in our current circumstances is going to put entities in a better position to respond timely and appropriately once those requests are coming in. So again, I thank you for your continued work. We will get through this, and I think that we are all going to learn something during these times that's going to make us work even better and smarter once we come through this experience. So as you puzzle through these things, the Data Practices Office is here to help you out, so please reach out to us. So as we move to your questions, I'll put the PowerPoint and guidance document up again for those of you who want to download it. Also, as I mentioned, this is being recorded, and we will make that available to you on our YouTube channel. We want to be respectful of your time, so if we don't get to all your questions during the webinar, we can certainly follow up with you. And if it makes sense to do this again in a couple of weeks, we're happy to do that as well. Now I'm going to turn it over to some of my colleagues to start responding to the questions that you have been asking.
All right, we've already got quite a few questions coming in. First question is, if some members of a council attend at the regular meeting place, would that throw into question a determination that meeting in person is not feasible? So I think this question makes a good point. There are two different unfeasible determinations in 13D.021. One is whether it's unfeasible for members of the public to be present, and the other is whether it's unfeasible for at least one member of the body, the chief legal counsel or the chief administrator, to be present. I do think that the more people that you have present, a court may look at that as a determination on whether or not it was or wasn't feasible. Because we now have this stay-at-home order, I think that a determination that's not feasible is much more reasonable. Next question. How should a local government document the decision to hold a remote meeting? Is this an executive officer memo or something more formal? So the 13D.021 doesn't say how to document it. It just says that there has to be this determination by either the presiding officer, the chief legal counsel, or the chief administrative officer. Whether that's in a memo or it's stated at the beginning of the meeting or in some sort of other document, that's more of a procedural question for each body to determine how they're going to accomplish that. Next question is, has the Chapter 12 Peacetime Emergency been extended? Yes, it has. A peacetime emergency must not be continued more than 5 days unless extended by resolution of the Executive Council up to 30 days, and the Executive Council did extend it. We have a question asking us to provide copies of PowerPoint. We do have those on file transfer right now. It should be showing up on your screen. So if for some reason you're not able to download and save the documents on your screen right now, send us an email afterwards and we'll happy to send that to you via email. Okay. Another question, most of our motions are approved unanimously. Would it be okay to call the question for voice vote and only roll call when the result is not unanimous? Purely a matter of simplifying the process. So the law is silent here. All 13D.021 says is all votes are conducted by roll call. It doesn't have an exception for unanimous votes. So technically the law just calls for roll call in these types of meetings. Another question is, are you encouraging public entities to prioritize requests related to COVID-19? I think they're talking about data requests here. You know, that's a determination for each entity to make on how procedurally it's going to handle requests at this time, and what you have in your data practices, procedures, and policies regarding how you respond to requests and in what order. Some entities have a one request at a time policy. Some prioritize data subject requests first because those have that 10 business day requirement. So that's really an entity determination to make procedurally. A couple people have mentioned that the volume has cut out. I'm not sure if that's for everybody, so I apologize if you're having any sound issues. This will be recorded and we'll be posting it on our YouTube page. So if you're having any sound issues, hopefully you'll be able to tune in later on our YouTube page. All right, we're just reviewing some of the additional questions that are coming in.
All right, so we have a question here. Do you have to, and how do you give notice to the public that a meeting will be done electronically? So what you're going to want to do is take a look at 13D.021 subdivision 4, which provides all of the requirements and kind of explains how to notice the meetings. And so it does include, including in your notice, following the regular, special, or emergency meeting notices, and then also the fact that some members may participate by telephone or other electronic means. So yeah, under 13D.021, you would want to notice that some people may be participating electronically.
There's a question whether the 10-day rule is still in effect. So I think this is referring to the data subject response time for 10 business days. Technically, there's not an exception in the Data Practices Act for the 10 business day response time for data subjects. And so, that depends on, I guess, who's still working during this stay-at-home time. But a lot of the recommendations that we had throughout the webinar discussed how to kind of facilitate moving forward with data practices during a state of emergency.
All right, so one of the questions here for the roll call votes, if the clerk can see all the council members, I'm presuming votes on the screen, does that count? Or does the mayor have to call each council member by name for every vote? That's a good question. The 13D.021 simply says that all votes must be conducted by roll call. And so it probably really depends on the way that you are operating your meeting. If it's simply through telephone, certainly you would need to obviously make sure to get a voice vote for everybody. If it's on the screen, that may be a possibility, but I would also consider that there may be other people who are members of the public who are on the phone, and so they might not have access to being able to see what the votes are on the screen. And so really you would want to consider your technology and kind of the capabilities as you're considering those votes.
Here's a question that says, what language can we add to our notices related to COVID-19? So I think they're talking about their notices under the open meeting law for their future regular and special meetings. There's not anything additional to add specifically related to COVID-19 unless you want to add additional information for your constituents wherever or whoever's going to be attending your meetings. If you're holding the meetings under 13D.021, it would be helpful to include that information on that meeting notice and explain that you're holding it under this section because of the health pandemic and emergency that's been declared because of COVID-19. Things that might be helpful to whoever is attending your body meetings. But there's nothing specific that's in the law other than what you would regularly include on your meeting notices and how you're holding that meeting.
All right, another question here about how to hold a board meeting if the office is closed or if your office is closed. Can the chair and legal counsel meet in a room and have other board members attend via telephone? Yeah, under 13D.021, subdivision 1.4, it does say that at least one member of the body, the chief legal counsel, or the chief administrative officer is physically present at the regular meeting location. That can certainly qualify, of course, unless it's unfeasible due to the health pandemic or emergency declaration. And so that would be up to your body to determine whether or not it's unfeasible unfeasible, excuse me. Of course, right now, when we're kind of in that stay-at-home phase, it probably is unfeasible. But certainly, after this kind of maybe settles down and there's still continuing to be social distancing, certainly that's a possibility to have the chief legal counsel or the chief administrative officer being physically present in the regular meeting location while others attend by telephone.
There's a question that says, regarding presence at the meeting place, does members of the public body include the council or members? So what the law actually says is under 13D.021, subdivision 1.4, at least one member of the body, chief legal counsel, or chief administrative officer. So it could be, one of those three individuals that would be physically present at the regular meeting location. But again, unless unfeasible due to the health pandemic. For those of you, if you have moments of silence, it's because we're trying to scroll through all the questions we're receiving and read them. So if you have if there's a moment of silence, just hang in there and we'll get to your questions.
We have one question about Chief Administrative Officer is not a term we have used in any documents for our agency. Can we presume who that is, or do we need our boards to designate it? I mean, I think now is a great time to figure out who that is. And in terms of documenting who that is, I'm not sure. Again, I think that's kind of internal process to your public body, how you memorialize that in some way. But if you don't have a Chief Administrative Officer right now, it's probably a good idea to think about who that is for your public body.
Someone just asked, what email address do we use to send requests for the documents from this webinar? You could just send a request to the email address that's on our screen right now, so info.dpo@state.mn.us. Somebody said that they couldn't hear the last question and answer. The question was regarding presence at the regular meeting place. Does a member of the public body include the entity's legal counsel, or is it just the appointed members? So 13D.021, subdivision 1.4 says at least one member of the public body, the chief legal counsel, or the chief administrative officer. So it could just be one of those three individuals. But again, that's unless attendance at the regular meeting location is not feasible due to the health pandemic or emergency declaration, which at this time it likely is not feasible. Or that would be a reasonable determination to make.
Someone asked if we can compile all these questions and put them in a written format, and yes, we are definitely happy to do that for you. So someone asked if the files from today's webinar are going to be available on the website. Right now on our homepage, the guidance that went out on our listserv about the open meeting law data practices is already there. There's a link right on the homepage. It's also the document that I shared during the presentation. The presentation and the webinar, the recorded webinar, will be on our website as well as soon as we can get that up there. And then, yes, we can compile these questions as well and put them on our website. We had a question about what the definition of chief administrative officer is. The open meeting law does not provide us with one, so I think that's going to be up to each public body to determine. Some agencies may have delegations, so you can look in position descriptions or appointments that might document who that individual is. Thanks, Lori, for that. So there's another question. Are there any particular areas of the Data Practices Act or types of data for which you anticipate local governmental entities will be receiving COVID-19 related data requests? We really don't know, or we really can't anticipate. So I think just your usual being prepared to respond to requests as you usually are, and you'll be in a good position to do that. Okay, I think we have one more question, and the silence you're hearing is that we're just waiting to see if anybody else has any questions. This one is for boards legislatively required to hold quarterly meetings. Are there any specific exemptions to this requirement during a state of emergency stay-at-home order, or does the board's ability to hold meetings via telephone or other electronic means work, I think is the question. I'm not aware of any other specific exemptions, so I think that you can, if you are subject to the open meeting law, you can certainly use 13D.021 to hold your quarterly meetings by telephone or other electronic means. Okay, so we're just going to wrap up here. We are at the end of our time. As I said, we will definitely take these questions and try to get some written guidance up for you. The recording will be available to you. Email us, call us. We're here to answer your questions. Thank you for your continued work and thank you for joining us today. Please let us know how we can help you during this time.